Hello, good afternoon. Maraming salamat, JJ. Thank you for inviting us. I speak for lahat ng mga dinamay ko. When JJ called, we go back a long way, and he broached to me the idea of something like this. I guess it was part survival that it's very hard to discuss human rights and in the digital sphere in just one go. So I started suggesting names for possible areas, and JJ picked up on that, and uh, they now have a three-part series, which elates me because it gives us more time to do a deeper dive rather than what I will be doing today, which is really like a helicopter ride of the issues involved. Sort of to preface the whole series and to give everybody some parameters of how we are looking at human rights in digital environments. So it's I will be interchanging the terms. No, it's really human rights in digital environments. It could be ICTs, the use of computers, etc., but also the internet. And in many ways, in the internet is social media for many. So we'll be touching on a few things on social media. Um, some people term this as digital rights. We refrained from using that before because digital rights management was a very controversial term before. It was IPR related and enclosing content and knowledge. But it's now, I think, digital rights has become more accepted. Internet rights is also one term that has been used by advocates, specifically because we are all netizens, and what are our rights in that? If digital citizenship is part of our personas now as either digital natives, the younger ones among us, or digital immigrants. We are my generation. We are all digital immigrants. We didn't have the internet before. During martial law, we didn't have the internet and social media. So, but now we are deep into the internet, and if you look closely at when I joined FMA, I revived FMA in '96. The internet just came to the Philippines in '94. We are celebrating we just celebrated the 25th year of the Philippine internet. So so that's where we are, and I'll now share my screen. Mm, uh, can everybody see? Okay.
Looks good.
Yeah. Straightforward title: Internet rights are human rights. Locating human rights in digital environments. Mm, a very short roadmap will be just sort of contextualize what the impact of internet and ICTs have on human rights discourse, and then I'll go right away to emerging human rights issues in digital environments. I will try to sort of deconstruct and simplify a very complex topic because if the internet is everything now in our lives, well, it's very hard to explain in 20 or 30 minutes uh, what the impact will be on rights on all these arenas. But I'll try. I'll deconstruct it a little bit. I have a typology which might help. I'm not sure if I can reach the third part, which is initiatives, efforts of human rights defenders online. But no problem. I can skip that part. I guess I've been using this slide for forever. I think I first used this maybe 12, 13 years ago, where we were explaining that the impact of the internet on all aspects of human life, no? Especially and particularly in this case on the concept and practice of human rights, since human rights are embedded in human lives, as Duterte would say. I will not get into definitions of human rights. We all sort of um, know it, but I stress this because uh, these characteristics of human rights, universality, inalienable rights, they are interrelated, interdependent, and indivisible, finds a specific significance in the digital sphere when you overlay technology, when you overlay a digital identity into everything. And as we will see towards the end, the complementarity of offline and online. So it's very hard to separate now the offline life and the online life. I'm sure everybody knows that intuitively, but we will try to show that in the human rights sphere. Why are internet rights becoming important now? Well, uh, firstly, it's really because of the advancements in technology and how it has enabled all of this. The first three circles are really what we were seeing maybe 5 or 6 years ago, that this was where it was going. Mobility, rise of smartphones, and then a lot of sensors and sensor networks and tracking and all of these things, and the rise of social media. Since then, since I was using this slide, there have been lots of advancements in the area of the use of algorithms and smart technologies and big data and the Internet of Things. Things we wear, our appliances, our watches, our refrigerators will tell us when we have milk. Our watches will tell us what our heart rate is. It's embedded in everyday things. And artificial intelligence, we'll not get into that, but this is a new frontier even for human rights advocates, because how to prescribe these new technologies in a topic, human rights, which had a very analog history. Yeah. The Universal Declaration of Human Rights, which incidentally is on its 75th year, was signed because of the horrors and atrocities of World War II and all the killings that happened and all the torture and the bombings, etc., etc. So, how to migrate this into new realities of digitization and computerization, and how that has embedded itself in all aspects of our lives is a key driver for this discussion. I'm going to deconstruct rights and the internet this way. Um, we used to divide it into the first two. First is the rights to the internet, meaning um, questions of access, accessibility for people with disability, and the very crucial affordability question. Who can afford to be on the internet? We'll talk about that a bit later, but it's the rights to the internet. Do we have a right to the internet? The same way that education has developed, that we now have a right to education. Then I guess the more easily absorbed concept is rights on the internet. Without the internet, we have rights. What happens when we have the internet now? So this is a clearer migration of your rights or offline, your right to express yourself, to associate, the right to privacy, and your gender rights also exist in a virtual world. So we'll talk about that as a whole basket of rights on the internet. The third is something I've been developing the concept of. I don't know if the preposition is correct, rights in the internet. Because what we're seeing is there are specific rights related to digitalization that have not had not been sort of uh, contemplated by an analog reality. I'll explain it later, but for now, let's refer to this as extended rights that are unique to the technology that we are all experiencing now. So that's our, in a sense, our roadmap: rights to, rights on, and rights in. For rights to the internet, I think this is very clear. That's why I push that you talk also to Grace, because your third webinar will be on uh, a, 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 a law, a proposed bill that would seek to broaden access in a situation where the Philippines has one of the most expensive yet the slowest internet, not only in Asia but globally. Uh, but that derives primarily from the right to be digitally included, the right to meaningful access to the internet. If the internet is very important now, then what will it say if only half of Filipinos are on the internet? Especially in a time of pandemics. Half the world is still not connected. The affordability question, again, we work. Lisa continues to work with the World Wide Web Foundation and the Alliance for Affordable Internet. They have broken down the affordability question in many relevant ways, like how many days do you need to work to afford a smartphone, which will be your access device? And you will see that they have lots of data on this, and the data points to the fact that many still don't have access. A September 8th report says that before the pandemic, only half of adult Filipinos were using the internet. Which begs the question, in a situation where many are unemployed and without income, uh, and hunger rates are going up, how many do you think will prioritize internet over food, right? So I expect this number to be lower during the time of COVID. Well, there are lots of estimates about how many, but I think this is very telling. In terms of the right to the internet, it's been a process. I was in the World Summit on the Information Society, which was informally the World Summit on the Internet in 2003 and 2005. We were part of the Philippine delegation, and we were already talking about access because, of course, the Europeans and the Americans had access, but the Africans, the Asians, and the Latin Americans did not. So it was front and center on the agenda of that summit. And then as it went along, countries started to consider internet and connectivity and even broadband connectivity as a right. And even the UN Special Rapporteur acknowledged. In 2012, he said that it is not yet a right per se, but governments are being encouraged to make it widely available and affordable to all. As countries started considering this a right, many countries passed laws or even included it in their constitutions to characterize internet access and broadband connectivity as a right. And we have lots of national examples. In 2017, I think this is a milestone in terms of intergovernmentals declaring that the internet is like water, right? And we will have to move into a situation where it is an essential right for all. And this particular declaration was also coming from another reality, which was some governments were denying access to certain populations or at certain times, or certain regimes were limiting access. All of this was bubbling under the surface, and um, so if for people who already had access, a deliberate disconnection from the internet was being framed as against international law. There is a whole community just monitoring internet shutdowns. So one aspect of the right to the internet is the rights of those who have no access. But there's also the rights of who have access, however limited that may be, but who are denied access in specific episodes or times or contexts. So you have macro level filtering, like the Great Firewall of China, but there have been episodic shutdowns in many countries up to today. In Asia and Africa, Myanmar, etc. The number one, I've read that the number one country which has the most number of internet shutdowns in 2019-2020 is India. There is data about the internet shutdowns, and it's being so. There is a campaign, keep it on, hashtag keep it on. You can go into that. And there are different reasons. You can see that the reasons that have been studied are, well, public safety, national security, similar to how our government would frame if ever they would, heaven forbid, shut down the internet. But this brings me to this is not just an issue of rights to the internet, but it bleeds into the second category of the rights on the internet. Because for the simple reason, and very simplistic reason, if you deny access to the internet, you're denying voice to those who are using the internet to share information, to share advocacy, to protest, to share knowledge, to do education. So it transcends into the rights on the internet. So the succeeding webinars will tackle this in a deeper. I will just helicopter on a few current issues that touch on let's say freedom of information and freedom of expression. Unlike China or Bahrain or or India, we do not have wide-scale internet shutdowns. I think the tradition in the Philippines is like the tradition of media. It's basically not regulated after martial law. There is freedom. It's a freewheeling media, sometimes to its detriment, but it's very difficult coming from the martial law years to shut it down because we've had that experience before. But what has happened is there is a history of technical filtering, like DDoS attacks or attacks on certain websites to put it down, etc., etc. We have documented that through the years, but in the recent past, um, we are seeing a different way that is also a trend in some countries like us, where law, legal regulation has been used, ostensibly passed in a democratic way by Congress. They did not shut down Congress. Congress is the one that passes it, etc., etc. But they are problematic from the traditional view of free expression. I will not go into these things. I will rely on Romel and Jam and all of the other speakers to talk about this. But just to mention the Cybercrime Prevention Act, because I was limiting my slide, but I wanted to show a slide I was using before on those who filed petitions against the Cybercrime Prevention Act of 2012. And one petition was led by none other than Jesus Dicini, Esquire. Um, we were part of a wide opposition against the Cybercrime Prevention Act, the Supreme Court, but it passed. And we are seeing now that some of its elements are problematic. And we've seen this recently in the Rappler case against Maria Ressa, when a private person, ally of the government, filed a cyber libel case with very flimsy reasons. Anyway, we'll not get into that. I'll flag that for Romel and the others in the succeeding. You can see certain things to regulate content, like the Bayanihan Act has an anti-fake news provision. Again, it's problematic because who decides what news is fake and what is not? And then the very controversial Anti-Terrorism Act of 2020, which will surely be discussed by the next webinar. And it's not just content-related laws. That's how we call, let's say, libel or defamation or fake news or disinformation or all of these things are content-related. But lately, we're seeing in the ABS-CBN shutdown that the power, the licensing and franchising power of the state has been used to shut down the biggest media organization in the Philippines. And it does not just deny 11,000 people work, but also entertainment for many people, knowledge, information in a time of pandemic. There are a lot of rights that were sort of violated with that closure. And then, yeah, we've had a lot of ink on regulation of content. That is a flag for freedom of expression advocates, because there are laws against harmful content, libel, defamation, whatever, if spreading, whatever, if you, the proverbial, if you shout fire in a movie theater, malabo yun, di ba? So, but even without the anti-terror law, there have been already arrests and using the problematic cyber libel provision. This is interesting. In August, SWS reported results on half of those asked agreed that airing or printing of government criticism was dangerous, even if the criticism was true. If you say something against how the government is handling COVID or how they are red tagging people, etc., but it is dangerous. This is the classic example of a chilling effect, and that's what we're involved. What is involved here. That most of these laws and regulations have the overall effect of chilling free speech. Instead of freely expressing one's opinion, uh, people will self-censor. The public sphere will be less open and free because there is a threat that you will be charged or held to jail. FMA was monitoring this because this was right after, I think, the Maria Ressa conviction, and these were people who were posting on Facebook complaints about certain companies which had poor service. And they suddenly received letters demanding apology for damaging Facebook posts. Chilling effect. The second area which I'll get into because it's very sort of relevant to the current milieu in the Philippines is disinformation. We all know what that is. It's a very toxic environment. Even COVID-related, there is non-political disinformation, health assertions which are not true. There is long-standing historical revisionism of the martial law years and the legacies. There are hyper-partisan attacks online on public figures or politicians using fake news. Laila de Lima is on jail and partly because that there was this fake video of her having sex with her driver, which is totally fabricated. And with the technology what it is and developing the so-called deep fakes, it will be very problematic to distinguish what is a real content video, for example, or voice. So, and of course, if I have time, I'll get into the role of platforms. But to the credit of Facebook as the number one platform in the Philippines, number one social media, it has taken down various accounts, content sites, which has been deemed to be engaging in coordinated inauthentic behavior or CIB. I think there are three waves of takedowns. This is the second wave, I think. 2018, I know there was one. And then recently, links to China sites, China originating sites, links to campaign sites of Sara Duterte have been deemed violative of community standards and authentic behavior. So, of course, the military raised anyway. So, the third sort of example I would sort of look at as very relevant to the Philippine situation is surveillance. And we've had a trend of surveillance. That's why we were pushing very hard for a Data Privacy Act. It did not satisfy all our desires for a comprehensive, but it's a Data Protection Act which we supported. In fact, FMA was the first to file a complaint, which there was no complaint process yet then by the then Data Privacy Commission, National Privacy Commission, on the COMELEC leak of information of voters. Um, Fast forward to now, to today, and COVID-19 is the reality which we all deal with. But as globally, it has been an excuse for governments and private companies to access personal information many times without consent or full consent, free prior informed consent on all that they do with our data, and using the health crisis to normalize a situation of an emergency, which we feel might be normalized even after the emergency, because the emergency is, we don't see the end of this emergency, no? So and in the middle of these things, there's the national ID system, which is FMA has good materials on the problems of the national ID system, PhilSys. And then this is also I will flag the national DNA database, which some congressmen are copying from other jurisdictions. We don't even know what our DNA says about who we are. But there are already moves to commercialize it. All of these services which you give your blood, they will take your DNA, so they will detect your pre-existing conditions or your proclivity to disease, etc., etc. It's been fantastic how much we are giving up our personal information to companies and states. Just this past few months, there was a multi-stakeholder effort by not only Philippine agencies and NGOs, but also regional, Asian, and also global, Civicus, Privacy International, APC, on the initiative of FMA to write a letter to the IATF asking for clarity and transparency on the contact tracing efforts that were being proposed and authorized. Awa ng Diyos, hindi yata sumagot formally ang IATF, ang DOH, ang DICT, at ang Multisys. Pero if you look at the petition, you will find out the letter, you will find out what the concerns are when personal data is being required and there are no safeguards. It violates some of the privacy principles of proportionality, etc., etc. Anyway, so I'll try to wind down because hopefully we understand the rights to the internet discourse and the rights on the internet. I'll briefly, it's a bit technical, but bear with me because we are all in the digital sphere. We have to know some of these things better. So I'm calling it rights in the internet. These are rights which have not been contemplated by usual human rights law or usual concerns of social justice, etc., etc., because they are embedded in how the technology works itself and what problems arise out of these and what should be a rights-based response. First is network neutrality. Think of it this way. There is free Facebook, right? Free Facebook, Facebook Zero, etc., etc. And they have made a deal with the telcos. This was my debate with Jim Ison long time ago. But we feel it was violative of network neutrality, which basically refers to if content passes through your pipes, you should not discriminate on what content you will allow and what content you will not allow. What content you will give a fatter pipe to and what content you will give a thinner pipe to. In other words, it's easier to download the content of Facebook because they have a deal with PLDT and Smart and Globe than it is to download a human rights website because they do not have that. They are not paying or they're not revenue sharing. So this has been raised by pioneers of the internet that the internet was supposed to be neutral. It's like a telephone wire. When I call you, you do not listen and say, what you will talk about is less important than what another person will talk about in another call. So that is what we call content agnosticism. You're agnostic to what content passes through the internet. And we have seen many, many instances where this is being violated by the telcos, by the platforms, by rich content owners. Okay. So I hope I clarified that. So network neutrality. So do we have a right to demand from providers that they will not, first of all, snoop on our content to be able to decide whether our content is worthy of a faster access pipe or not? So that's one. Secondly, this was famous for a couple of years ago. The right to be forgotten was filed in France. It's not that straightforward that the right to erase everything that's on the internet about me, because the internet never forgets, right? So if you posted a nude picture of JJ Dicini online and then you erase it, chances are it's still on the internet somewhere. It had been shared or whatever. And there was this landmark case in France on the right to be forgotten, which related to search engines. Let's not get into the legalities of that. But the point is, do we have a right to control what type of information? Let's say I was a drug addict before. And then now that's very hazardous to one's health to be labeled as a drug user. People get killed for those things here in this country. According to many, the numbers are upwards of 30,000. So, do we have a right to demand that search engines filter the content if it's irrelevant, if it's 19 kopong-kopong pa, etc., or not? So that's one. Do we have a right to be forgotten? The right to encryption and anonymity pertains to many in conflict or crisis areas where states are hunting them for what they do, human rights. So they have to communicate secretly or confidentially. So the internet has allowed this. There are a lot of encryption protocols, etc., and systems. But many states are trying to break this right by disallowing encryption over their networks. So it's a problem for human rights defenders because this will expose a lot of vulnerable people and populations to harassment and even death. And anonymity is also a debatable thing. People are saying that we always have to use our real name on Facebook and all our platforms. But again, if you are criticizing a government with thin skin and every post that you make is filtered and monitored and might be potentially a cyber libelous post, there are some context which anonymity might be the better part of valor. And there are many countries that have disallowed real name policies. Korea, the most connected country in the world, has been very strong on right to anonymity. The last thing I'll mention is, again, we are all on Facebook and Twitter and Instagram, and I can't get into this, but the algorithms that are at work, the machines that filter our content and then process it and then decide what content they will show you. For example, based on your previous choices on what you see on YouTube, YouTube will suggest content, videos that you might like, or they may suggest videos that have paid. Add money. That's a big business now. Digital advertising. A recent study came out that about disinformation on martial law. LaSalle scholars, Che Soriano and her colleague, have studied how much the content that pro Marcos, pro BBM, etc., content is being shared by those site owners who are know the system of YouTube, exploit it, and use all sorts of manipulative behavior so that what appears on the search for martial law will be the fact that martial law was the golden era of Philippine history. And we were richer than Singapore, and Marcos had a ton of medals, and he was very rich, so he does not need to steal from the Philippines. Anyway, this demand has been raised that the algorithms are like black boxes, which we cannot see how these things happen. And there have been many studies in many countries where it has been proven that there are very discriminatory algorithmic decisions, either on blacks or colored people, on women, etc. There have been a lot of books that have come out on algorithmic discrimination. So, in this new milieu, should we have a right to know how the algorithms are interpreting our choices? And that's exactly what Cambridge Analytica did, no? With Facebook. They manipulated the systems of Facebook and the algorithms of Facebook so that and gathered a lot of personal information so that they can shape the content that they will now um, make viral. So these are, again, to recap, these are new extended realities of the internet where new rights may have to be developed in some sort of national or global consensus. And many of this relate to data. We are our data. People have tried to get it. It's the oil of the 21st century, data. So all of these platforms and social media companies are personal surveillance mechanisms to be able to get our choices, our what we want to shop for, our religious or political options, etc. And then market. I'll end with this series of slides to see how complex it has become. I broke it down so we can simplify it, but now I'm trying to reassemble it and to show the complexity. So now freedom of expression was very clear. Article 19, all of these things, UDHR. But if you overlay technology with freedom of expression, so am I free to express if the platform will censor or filter my content depending if they believe that I should have a thicker pipe or I pay? Is paid, will there be a tiered internet where those who pay will have a faster internet and those who do not pay cannot pay? So isn't my right to freely express affected by that, by net neutrality or the lack of it? Of course, connectivity. How can I express my freedom online if I'm not connected? So COVID is exacerbating the digital divisions in society, by exacerbating the inequalities, digital inequalities. Privacy rights. If I know that I'm being surveilled, will I be as free to express my real opinion or not? Of course not. And security. If people will hack into my accounts, why will I continue to be on Facebook? I'll just leave Facebook because they will spoof my identity and my account and they will send all sorts of harmful content in my name. Uh, anyway, that's where I'll end. Internet are human rights, and I'll skip this. Maraming salamat.